All right, great. Yeah, thank you for your patience, everyone. Just getting the live stream going on YouTube. Welcome to the October Mine Land Reclamation Board meeting. First off, I'd like to do roll call of the board. Mr. Mock.
Present.
I'm sorry. Ms. Nelson. Present. All right. Quinn.
Here.
Mr. Singletary here. And Nell.
Present.
All right, thank you. And did everyone have a chance to look at the September summary of minutes?
Motion to approve.
Second.
All right, have a motion and a second. All those in favor?
Aye.
Aye.
Motion passes. No continuances or withdrawals at this point.
There's not.
Okay, and it looks like we have one item that moved to the consent agenda. Oh yeah, I'm sorry. But first off, we will have executive directors and division director reports.
Good morning, Mr. Chair, members of the board, Acting Director Cunningham, Tim Mock, Deputy Director for Department of Natural Resources. A couple of updates. First, I want to start off by welcoming new board members, Karn Stingelmeyer and William Baker, who will be joining us next month. Karn is a former Summit County Commissioner. I've worked with her a lot over the years, good friend, and so excited to have Karn on the board. She's got a wealth of knowledge. I think we'll all enjoy working with Karn and look forward to meeting Mr. Baker when he joins us. William will be replacing Mr. Singletary, who we really hate to see go after all of these years in service to the state. So, but with that, we're going to have a little celebration before you leave in your honor. The DNR continues to kind of work on the November 1 budget submission from the governor's office. So kind of been busy doing that as well as pulling together the final agenda. So I think by our next meeting, I'll have some updates on what that all looks like. The executive director's office and DNR leadership will be meeting. Actually, I'm headed down to Durango area and Ignacio to meet with the Southern Ute Indian tribe tomorrow, and we'll be back up Friday. And then also, I want to thank Acting Director Michael Cunningham for stepping in the role. We really appreciate his service, and also for the DRMS team for working with Michael during this transition. Late last night, the DRMS director position was posted on the state website. It'll be listed, I believe, through November, about 7th or so. But it'll be open for about 3 weeks. We're still kind of gaming out the entire process and what that looks like. I'll have an update at our next meeting, but suspect we'll begin getting the applications there at the beginning of November. Takes them about a week for HR to do a first pass through, and then a review panel will identify preferred applicants to interview, and then we'll have some interviews probably before or more likely the week after Thanksgiving. So probably looking at a hire later towards December, the beginning of the year, perhaps. And with that, we also continue to thank Jenny Brandon, if she's listening, for her service, and we all miss her around the Department of Natural Resources. And with that concludes my remarks. Thank you.
Thank you, Mr. Mock. Michael.
Good morning, Michael Cunningham, Acting Division Director. As you know, I'll be filling in here this month, maybe likely next month. So I'm excited to be sitting up here. I'll be wearing a couple different hats for the next few months. As far as the update goes today, it's largely a personnel update. I want to first start by welcoming Jocelyn Carter, one of our newest EPSs, who joined the Active Mines program on October 9th. Jocelyn comes to the division with extensive experience as a field inspector, performing independent audits for asset verification and risk management. line of work, which gave her a lot of experience working around heavy equipment. Jocelyn is a current member of the U.S. Army Reserves. She holds a Bachelor's of Science in Environmental Science from Oregon State University and will receive a Master's in Science in Hydrology and Water Security from the University of Oklahoma in December. And she will be sitting on Jared's team. So welcome, Jocelyn. I'll also let the board know that we have filled a budget director position. Elena Lazarevska will join our team on November 6th. She comes to the division with a wealth of experience working for state government, starting off in the state of Ohio, working 7 years there, including for the Ohio Office of Budget and Management. Following that, she worked as a senior financial analyst for the city of Boulder and most recently for Colorado Parks and Wildlife. So we're incredibly excited to have her on, and we'll make sure to introduce her when she starts here. Also, another announcement, April Allen, one of the Active Minds accounting staff, will be taking another position within a state agency. Her last day will be the 20th. And so certainly our loss is another agency's gain, but we wish her all the best. And just wanted to take a second to note that oftentimes the board sees our environmental protection specialists that of course come before you every month, but we have a lot of admin, support, budgeting and accounting staff that do really incredible work to make sure that we can do the day-to-day and keep the office running. So we wish April all the best. And lastly, I just echo Tim's comments concerning John. John's been on the board since about 2015, has graciously served that time. And I'd say your insight and your expertise have been invaluable to this board. And so we thank you for your service. And that concludes my comments for this morning. Thank you.
Thank you, Michael. Yeah, a lot of transition happening here. And we thank the people that have been doing their service on this board for so long and providing insight on the natural resource agendas and oversight of business being conducted in our state. So thank you all. Next up, our consent agenda. Do we have Eric Scott? Was there anything to add or an update, or do we just need to?
No, this is just a consent approval for the first period temporary cessation for one of our operators.
Okay. Can I get a motion to approve the consent agenda?
So moved.
And I'll second. All those in favor?
Aye.
Aye. Those opposed? Hearing none. Motion passes. Next up, item number 6, an enforcement hearing for Mason Chamberlain, file number M-2010-043. All those providing testimony, please raise your right hand. Promise to tell the truth?
Yes.
All right, thank you. And go right ahead.
Good morning, everyone. My name is Amber Gibson, and I'll be representing the division in this enforcement action. So this hearing is for the Falk Pit number 1, permit number M. Oh. Just kidding.
Sorry.
How do you? Oh, I see. Pause. No, I don't know. It looks like it's working on there. No, that's not the same. meeting.
Not sure why it's up.
Mhm.
Go to this.
Or-
Wheel.
We'll pause just for one moment, just having a little technical difficulties here.
Should be. Tammy, any idea how to not share her notes and stuff like that?
Try going in there again.
Mhm.
Do hide the center.
Yep, if you go in and just share screen and then
Yes, down at
swap.
the bottom. Amber, what's the
Presentation,
little dust
yep.
thingy?
Mhm.
So you funded that to begin with and showed you notes. Yeah.
Yeah, it won't let me open it.
Won't let you in.
Nope. I'll stop sharing and try again.
We did a dry run this morning and it worked fine, so I apologize. Maybe
We'll just blame the AI that Zoom has now apparently embedded.
Trying to fix your presence.
I don't know if you see it. Almost. Something's happening.
Okay.
But
and
it's
then
the wrong
right
view.
click on the screen, yeah,
display set. And
and then go to hide presenter view. Other stuff too. Maybe there.
But then I-
so I worked this morning.
Down at the bottom left there.
Down there. The notes on the bottom. No,
There you go.
But this is what they're saying on YouTube, right?
yeah, I think so. I thought it
It's still like
should
the
be
full-
that. I don't
Yeah, it should be
understand.
that.
Just, let's just go with your.
Yeah, so you guys know for just the view on screen, I can't see her notes anymore. I can just see like the upcoming slide on the left-hand side, so I think it's fine.
Okay, thanks, Nell.
Thank you. Neil.
Yep.
So just do slideshow.
In person's gonna.
Oh, for it.
Well, yeah, I'm determined that virus.
Changing so rapidly.
Probably.
Well, back one more time. Redo. And I'll pick a different. One screen two.
There you
Screen one.
go. There you go.
Okay.
All right, looking good on our end here too, so.
Now
Cool.
you advance, advance the slide.
Well, it up there? No,
No, I think you have to start the slideshow.
okay.
There we go.
Things are happening. Okay.
Good.
Okay,
All right.
everyone can see it? Okay, great. All right,
We're good.
all right.
Right ahead. Thank you.
Thank you for your patience. All right, so this enforcement hearing is for the Falk Pit #1, permit number M-2010-043. This site's permitted and operated by Chamberlain Concrete. And this enforcement hearing is for the consideration of a possible violation, cease and desist order, corrective actions and civil penalties, permit revocation, and finding the financial warranty subject to forfeiture for failure to protect areas outside of the affected land from slides or damages occurring during the mining operation. This site's located approximately 11 miles southeast of Paxton, Colorado. And the site's permitted as a 110 limited impact operation. It's for 9.9 acres. The commodities mined at this site are sand, gravel, and clay. And the post-mining land use is wildlife habitat. The division currently holds a bond of $30,800, which the division has determined not to be adequate at this time. Since the mine permit was, since the permit was permitted, there have been no updates or no revisions to the mining plan map. So the mining plan map originally submitted with the application is the currently approved map. And it's not changing anymore. There we go. Okay. So the division conducted a routine monitoring inspection of May 2023. The red polygon on this image indicates the approximate permit boundary. This was estimated from the approved mine plan map and from the approved acres. During the inspection, the division also located 2 boundary markers, and those are indicated by those red flags on the image. However, it doesn't appear that those correlate with the approved permit boundaries. During the inspection, the division also determined the westernmost extent of the site, and that is indicated by the photo icons 19 through 23 on the west. The yellow polygon in this image indicates the areas disturbed outside of the permit boundary due to finding or affected land caused from mining operations. Through on-site observations during the inspection, including pictures and using aerial imagery from Google Maps and Bing Maps, the division estimates the disturbance off-site to be approximately 1.86 acres. If we look at photo location number 18, standing a little bit west of that southwest boundary marker that doesn't really appear to correlate with the permit boundary. The dashed yellow line indicates where the permit boundary approximately ends on the west side. And then the arrows indicate disturbance due to mining operations west of the permit boundary. At photo 19, I was looking southwest at the southwesternmost extent of the disturbance offsite, and it's kind of near where that tree is in that image. And then photo 22, standing at the westernmost extent of the disturbance offsite, looking east at an excavated pit. And then in photo 24, also looking southwest, it's kind of hard to see on here, but you can see some track marks leading into the stream bed. So on May 25th, 2023, the division conducted a routine monitoring inspection and determined that approximately 1.86 acres were affected outside of the approved permit boundary. These acres included additionally mined area westward of the permit boundary contained within the ephemeral meander of the Patton Creek. On July 24th, 2023, the division sent the operator a reason to believe a violation exists and notice of forward hearing letter. This letter was received by the operator on July 27th, 2023. Then on August 4th, 2023, the division issued a surety increase, sequence number SI2 of $15,007. And then on October 3rd, 2023, SI2 was due, and as of today, the operator has not supplied an amended or replacement financial warranty. Therefore, the bond is inadequate at this time. The division believes the reason for the violation is that approximately 1.86 acres were affected outside of the permit boundary. We believe that this affected land meets the definition of affected land pursuant to the statute and the rule. And the affected land meets the definition of being part of a mining operation pursuant to the statute and the rule as well. CRS 34-32.5-116 parent 4 parent I states that areas outside of the affected land shall be protected from slides or damages occurring during the mining operation and reclamation. Also pursuant to the grants condition and agreement parent 1 of portion of permit M-2010-043 indicates that the permittee is bound by all applicable requirements of the act and all applicable rules and regulations of the board. The permittee has violated this provision of the permit by failing to comply with the statute and can be found in default of their performance warranty. The division staff recommends that the board finds the operator in violation for failure to protect areas outside of the affected land from slides or damages occurring during the mining operation pursuant to CRS 34-32.5-116, parent 4, parent I. The division recommends the following corrective actions, that being within 60 days of the effective date of the board's order, the permittee shall supply fully approved, amended or replacement financial warranty as a response to SI2, bringing the bond to $45,807. This would be an increase of $15,007 from the currently held $30,800. Also, within 90 days of the effective date of the board's order, the permittee shall submit either a conversion application or an amendment application to encompass all the affected land at the site and obtain approval of the required revision within statutory deadlines. The board also recommend that the division also recommends that the board issue a cease and desist order pursuant to the statute. They may issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to off-site areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. The division staff also recommends that the board assess civil penalties in the range of $100 per day minimum and a maximum of $1,000 per day pursuant to the statute. And for each day that the site has been in violation, and the division believes this to be 86 days, beginning on July 24th, 2023, when the reason to believe letter went to the operator, to today, October 18th, at the board hearing. The division recommends that the board assess a civil penalty of $8,600 and to suspend all but $500 if the operator complies with the corrective actions. This brings the total penalty to $8,600, the total penalty to be suspended to $8,100, and then the total unsuspended penalty to $500. Do you have any questions?
Good, Mr. Moore.
If I could, the bond increase, was that related to the disturbance as well or to the operation in general?
It was to the operation in general. It was the same tasks and the same assessment of the costs that was previously updated in 2015. It just hasn't been updated since then. So all of the increase is due to inflation.
Thanks.
Any more questions from the board? Is the operator isn't present?
All right, Amber, you did make efforts to contact the operator, correct?
Mhm.
Yeah, so,
Okay, don't worry.
yes, staff did make efforts and stuff to contact the operator through several different methods.
Mr. Chair, if I may, with staff, is the operator being attentive to our communications? Or, I mean, because it looks like we issued the bond update in August and still haven't received that. Are we in communication with them?
The last time that I spoke with him was prior to issuing that surety increase because he had questions about the cost reclamation estimate. And then I have not heard from him since, but a member of my team is currently assigned to this county. And he had reached out to him for annual fees and reports and maps, and that was updated on their end. So we know that he's probably getting our correspondence.
Thank you.
All right, well, with that, I would entertain a motion. Oh, yeah, I mean, is there anything to discuss at this point with it? Hearing none.
I noticed, this
Go ahead.
question, I
Yeah.
noticed that was a pretty good drop from the penalty that was originally, even at 8,600, you were willing to drop it $500, which I concur with, but is there a reason for that if you haven't even talked to the guy? I guess that, that's a question.
So I guess part of it was when I was talking to him about the cost estimate. He had expressed that he possibly wanted to keep mining in that direction. And he asked what he could do to be able to do that. And I said probably we'd have to bring him to the board for a violation because he had gone offsite. But then to move forward, we can do a conversion application or an amendment. And it sounded like he was interested in one of those two options. So at the time, it sounded like he was willing to work with us on that. So we went with the minimum to assess.
And that would increase bond even more at that point in time with that application.
It depends if he went with either the conversion or the amendment. If he went with the conversion and wanted to increase the affected land, it would probably increase the bond, but if he decides not to go that route and just amends the affected land into the permit boundary and reshape the permit boundary to still be a 110 operation in less than 10 acres, then it likely would not increase the bond from what we have currently calculated. Because he wouldn't be affecting any more land at that point. He would be allowed to affect what he has affected and then reclaim it when he's done.
Thank you.
Yeah, it sounds like we just need to have diligent communication, so we're not like playing hopscotch or like, he decides to extend it again and then a violation, oh, I want to expand my operation, so
Right.
just trying to get aligned on the process so that he can conduct business as usual and not have to receive correspondence like this.
Right, at that time, it did sound like conversion was probably the option that would have worked better for him. And then we still went ahead and issued the surety increase because we didn't know which option he would pick, and also we are under bonded at this time, so we'd like to get that covered for now at least.
Yeah,
And part of the discussion on the civil penalty is we really were hoping to use that he would give it, that afford him the funds and stuff for that to come into compliance rather than just going to a civil penalty. And that was our thought process behind that, is to try to hopefully get that conversion or amendment in place and stuff rather than hitting them with a heavy civil penalty at this point.
all right, well, thank you all for providing that context. Any more questions or
I just
comments?
I'm
Yeah.
not gonna be here. I think it's important, and I wish we could have better correspondence, but we're really putting the little guys out of business in the state of Colorado. I think we need to be cognizant of that, in places like Haxton, for example. And, these guys are just making on a heartbeat and a prayer a lot of times. And, I just think we need to watch it, and I appreciate where you're going. But I think it's handy to stay in better contact with, but, it's important that we discover or realize that there's more than those counties along the Front Range, 85% of Colorado's population is within 30 miles of either side of I-25. So I think we need to be thoughtful about what we do, just as a suggestion on these. And babysit them a little bit. I know that gets tiring, but that's part of my role, I think.
All right. Well, yeah, we can take a motion if someone wants to do that.
I move that the board finds the operator in violation pursuant to CRS 34-32.5-116, parent 4, parent I, for failure to protect areas outside of the affected land from slides or damages occurring during the mining operation. That we issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with conditions of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. And within 60 days, of the effective date of the board's order, the permittee shall supply a fully approved, amended, or replacement financial warranty as a response to is it SI or S1? SI2, bringing the bond to $45,807, an increase of $15,007 from the currently held $30,800. And within 90 days of the effective date of the board's order, the permittee shall submit a conversion or an amendment application to encompass all of the affected land at the site and obtain approval of the required revision within statutory deadlines. And that pursuant to CRS 34-32.5 parent 7, a person violates a provision of a permit that the board subject to civil penalty, assessing a civil penalty of $8,600 with all but $500 suspended in the corrective action set above are complete to the satisfaction of the division within the required deadlines.
Second.
All right, motion and a second. Any further discussion? Or go ahead.
I have a procedural question. So what happens in a situation like this? Is this used to be registered mail to prove that the operator would receive the information or whatever and the communicate? Is this all done by email now? And if so, like how is that actually legally binding that we've done everything we can?
I can answer that. All of our correspondence and stuff is sent by certified mail. It still is and stuff. That's still the process. While we do a lot of things and stuff by email when it comes to board orders and notices and stuff, and that those are all sent certified mail. So we get those cards back. Yeah, and that's part of the legal record of permit and stuff.
Yeah. So we've been through all that on this. Yeah. I get it. I just wasn't sure like how we do that nowadays. So
yeah, that's still
issue, I guess.
I don't think there's that's deferred to the lawyers. I don't think there's a better way right now and stuff for that, for those legally binding documents and stuff that we need to send out. So that's how we do that.
Very good.
Yeah. Orders are still under the APA effective on mailing. That's why, staff works to make sure it's sent out, certified mail. I mean, Tammy would know better, but oftentimes if there's been email correspondence with the operator, it'll go by email as well, but it's always sent certified mail to comply with the Administrative Procedure Act.
Got it.
Very good.
All right. Thank you everyone for the discussion. I guess we'll just put up for a vote. All those in favor?
Aye.
Those
Aye.
opposed? Hearing none. Motion passes as written. Thank you, Amber. Thank you, Jared. Next up, yeah.
Can I have everybody raise their voices? Some of this people in the back can't hear right now.
Okay.
So I just want to make sure that everybody can hear that.
Okay.
And Patrick,
Yeah.
I just needed on the record that I will be recusing myself for item number 7. So I'm going to sign off. Okay.
Great. Thanks, Nell. It's on
Thanks,
the
everyone.
record.
See you next month.
And Mr. Chair, Mr. Council, I don't know how long the statute of limitations exist on conflict of interest, but I just want to again reiterate that I was a county commissioner in Click Creek County where Climax Molybdenum operates the Henderson mine. Obviously, I'm very familiar with those operations. I don't have any interest in that. I've not been in communications other than when they've appeared before the board here in the last 6 years since I was last county commissioner.
Thank you for providing that transparency statement, Mr. Mock. All right, so now we'll conduct. Oh gosh, sorry, my computer is the AI. Yeah. So it'll be Climax Molybdenum Company. Henderson Mine permit number M-1977-342 for an acceptance of interest in real and personal property as financial warranty in accordance with CRS 34-32-117, parent 3, parent B. And we will go ahead and hear testimony from Mr. Ebert.
No. Sorry.
This maybe while Jared is doing the technical side of things here, again, I'm Jeff Fugate, attorney for the division. I'll just give a brief intro to fill some time here until he brings up his PowerPoint. Hopefully it won't be too duplicative of what Jared's going to talk about. As some of you are aware, this financial warranty process has been about 3 years in the making, so it's been a long time. We did receive a proposal in October of 2020 with the board's permission. Staff worked closely with Climax and consultants and specialists to kind of move this thing forward. So we're pleased to present this to the board for consideration today. As I indicated, we worked very closely with Climax. We're essentially presenting what is an agreement, seeking board review and approval of accepting some unique forms of financial warranty in the form of water rights and real property, something that this board has rarely done. And so with that, I'll hand it over to Jared. I'm available for questions. I'm likely going to remain fairly quiet through this presentation, but if you do have any questions, please interrupt as we're going and we'll field those as we go. It's a long presentation, so bear with us. There's a lot of facts. Like I said, we've got 3 years of time that we're covering here in about a 20-minute presentation. So fill up the copy. Yeah.
There you go. I'll try to be entertaining. Yeah, so Jared Ebert, I'm with the Division of Reclamation, Mining and Safety. And as Jeff indicated, this is a formal public hearing for the Henderson Mine, permit number M1977-342. It's operated by Climax Molybdenum Company. And this is for the consideration of Climax Molybdenum Company's proposal to use real and personal property as a form of financial warranty pursuant to CRS 34-32-117, parent 3, parent B. So next few slides, I'll just kind of give a brief introduction to the site and just kind of present the board with the timeline that got us to this point. This type of permit is a 112D3 permit. The commodity that is mined at the site is molybdenum. Permit area is 11,877.5 acres. The type of mining operation is basically an underground mine and a mill site. The mine site is located 9 miles west of Empire, Colorado, in Clear Creek County. The Henderson Mill is located 20 miles south of Parshall, Colorado, in Grand County. So you have a map here that shows the location of the mine and the mill. They are separate. They are connected by an underground tunnel. So regarding the financial warranty, the current required surety set for the site is $171,125,253. The current bond we hold is $141,656,674.31. We are asking for a net increase of $29,468,578.69. So way back in October of 2020, Climax approached us and they submitted a proposal to submit interest in real and personal property as a form of financial warranty. And so we brought that since it's a little bit, out of our normal wheelhouse, we did bring it before the board to see if the board wanted us to pursue such financial warranty. So on November 18th, 2020, the board did authorize the division to conduct further due diligence to review Climax's proposal. So we began that process, and then kind of through that process in April 20th, 2021, they did revise their proposal by withdrawing some of their interests in property from consideration of financial warranty. So from November 2020, pretty much onward, the division has retained the services of an attorney, Amy Rule. She's with Reinhardt, Boerner, von Duren. I may have mispronounced that. But anyway, she is assisted with the title review and the other due diligence associated with this type of financial warranty, the documentation we need to provide for that security. We also retained Bonnie Rorick with Bonnie Rorick and Associates LLC. She assisted us in the review of the land valuations and appraisals that were submitted by Climax. And then we also retained Brett Bovee with Westwater Research LLC. He assisted with the due diligence regarding the water rights that we actually currently hold, but the Climax wants to utilize the increase in value of those water rights. Also during this process, obviously, the operator retained their own subject matter experts. We had a lot of back and forth, as you can see from the board packet, and that was actually only what I believe to be a real snapshot of the most important documents. We had more than that. So there was a lot of back and forth during this process to get to where we are today. So foundationally, what are we looking at? The applicable statute for this is CRS 3432-117 parent 3. Subpart B states the board may accept interest in real and personal property as financial warranties to the extent as a specified percentage of the estimated value of any such property. Any person offering such financial warranty shall submit information necessary to show clear title to and the value of such property. Subpart C, the board may refuse to accept any form of financial warranty if the value of the financial warranty offered is dependent upon the success, profitability, or continued operation of the mine, or the board determines that the financial warranty offered cannot reasonably be converted to cash within 180 days of forfeiture. Subpart F specifies that the proof of financial responsibility may consist of any one or more of the following, subject to board approval. So it could be a deed of trust and security agreement encumbering real and personal property and creating a first lien in favor of the state. Kind of mirroring that is the rule 4.9.1 specifies the board or office may accept interest in real and personal property as a financial warranty of not more than 85% of the estimated value of the property itself. Any questions before I proceed? We'll just kind of go into the proposal next. All right. So their current financial warranty is made up of a corporate surety bond. We do hold, the value of water rights as well currently. And then we do have a letter of credit. So the vast majority of the bond, about 93% there, as you can see by that pie graph, is more of the traditional type bonds, corporate surety and letter of credit. With this proposal, Climax would like to use water rights and real property and deeds of trust to cover the remaining, some additional surety. So they propose to use these form of bonds to cover about $37,076,425, or about 21% of the total required surety for the site. So there's a pie chart that kind of shows how that makeup would look. With the proposal, we would increase the value accepted for the water rights that they currently hold, and we would add properties to the land, bringing their total bond to $172,281,253. So next few slides, we'll just kind of go into some details of the property and water rights that they are proposing, just to give the board some background information on these. So first is the incidental water rights. The incidental water rights were originally diverted for irrigation use pursuant to a 1911 decree from the William Fork River tributaries near the Henderson Mill. The decree for they were decreed for beneficial consumptive use at the Henderson Mill for the following uses: industrial, domestic, municipal, recreational, irrigation, replacement, reuse, including for mining, processing, refining, transportation, and production of minerals and mineral products. Their overall value was found to be $9,996,800. Second set of water rights is the Skylark water rights. These rights are located downstream of the mill, and these include several direct flow water rights and one storage water right on tributaries to the Williams Fork River, including Skylark Creek, Battle Creek, Lost Creek, and Mule Creek. In the specified water court case, the Skylark water rights were quantified and changed to include all beneficial uses, including augmentation and the use by the Henderson Mill by exchange. The water rights may also be used for irrigation of historically irrigated lands. So the value of those water rights were estimated to be $11,626,500. There's a map that shows some of the relevant hydrologic features associated with those water rights. Henderson could probably provide more clarification on that if you would like. And so the land property that we are considering. The first set of property is the Henderson Mill non-industrialized property. It's located in Grand County. It consists of two parcels. The first one is 487.8 acres. And the highest and best use that was defined by this in their appraisal was for agriculture and recreational ranches. The value of the property was found to be $1,710,000. The second parcel is the larger parcel. It's 4,444.02 acres. And the highest and best use defined for that parcel is agriculture and recreational ranches with the potential to be developed into smaller gentleman ranches as demand warrants. The value of that property was found to be $11,260,000. Here's a map that shows the location of these properties. So it's adjacent to the mill site. Here's a close up of the aerial photo. The first parcel being to the south and the second parcel being to the north. Here's a picture of the southern parcel. And kind of a representative picture of the second parcel, kind of the common ground cover. The second set of property they're proposing is the Alkali Creek Ranch property. It's located in Gunnison County. There are two parcels associated with this property, and in the documentation that was submitted, those parcels are referred to multiple ways, and it got a little confusing. But essentially, the most common was the B parcel, which is the east parcel, is 440 acres. Parcel A is the west parcel, it's 800 acres. The highest and best use defined for these parcels is for two gentleman ranches with potential to be developed, the property into smaller house and cabin sites as demand dictates, and the use of the property for agriculture and recreational ranches until development occurs. The value of that property was estimated to be $8,810,000. There's a map showing the location of those two parcels. Aerial photo. So north of Gunnison, south of Crested Butte, just north of the Flat Top Mountain there. Pictures of the property of the west parcel, parcel A. Here's the east parcel. The Silver Springs Ranch property is the final one. It's located in Gunnison County as well. It also consists of two parcels, parcel C and parcel D. Parcel C is 182.03 acres and parcel D is 71.46 acres. The highest and best use defined for those parcels is the development of the property into smaller house sites with agricultural and recreation uses until development occurs. Those are valued at $2,410,000. It's a map of the Silver Springs site. The polygon's a little hard to read, but it's kind of that light blue polygon around there that defines the property. So pictures of the parcels there. Any questions before I move on? Okay. So then, as you can imagine, there's a number of statutes and rules that apply to this type of financial warranty. And what I'm going to do here is just kind of go through each of those and give the board a summary of basically what we found over this review, and then we'll get into what we recommend the board accept. So in accordance with CRS 3432-117.3F, basically, as stated earlier, this is the statute that allows them to submit this type of financial warranty. But it is subject to approval by the board, and we have worked with them to develop deeds of trust and security agreements that we would finalize to get this form of warranty accepted and in place. Now, the rules and the statute do limit the amount of money we can associate with these properties, that we can accept a percentage of their appraised values. So Rule 4.9.1 states the board or office may accept interest in real and personal property as financial warranty of not more than 85% of the estimated value of the property. Table 3, I gave you guys all a handout copy of our recommendation. And on table 3 of that is is basically this table. It lists out each of the water rights and the properties that's on the table. And we are recommending the board accept basically 75% of their appraised value, which is below the regulatory threshold of 85%. So we have percentage listed out there and then the associated dollar value of each of those parcels over on the far right-hand column of that table, which would bring the bond up to $169,827,253. So, Rule 4.9.1 states, any person offering this type of financial warranty shall submit current information necessary to show clear title to the properties and the current appraised value of the properties. This information shall contain a complete appraisal in a form approved by the board. And that references right back to the statute there. So CMC's original proposal on October 1st, 2020, and then subsequent communications we've had with them have provided the documentation that's required by that statute. And obviously, we've, as I've stated, we've retained legal counsel to review those in detail to help us get to where we are today. So in terms of the water rights, as you can imagine with water, there's a number of complexities that exist. Climax has obligations to supply water in accordance with various agreements and protocols that these subject water rights can be used to satisfy, such as they can be used as a supply source for the Green Mountain Reservoir in accordance with the protocol for Denver. Also, like Denver has the right to access Skylark water rights from a 1995 agreement. And Denver has the right of first refusal to buy the subject water rights based on a 2012 resolution. I apologize, I'm losing my voice, of course. So based on all the back and forth we've had with Climax and based on our attorney's review, we believe that these complexities do not impose a substantial risk to the state should we have to take possession of the water rights for the bond. We have found that the water rights are transferable. However, this could take greater than 180 days to transfer or sell the water rights. Based on our subject matter expert, they estimated it would take about 15 to 20 months to sell those water rights. We have reviewed their appraisals and we do believe their appraisals are adequate. So due to the complexities and the time to transfer and sell the water rights, the staff recommends the board accept 75% of the value of the subject water rights. For the Henderson Mill non-industrialized property, the water rights obligations that we discussed earlier and their disposition may actually affect the value and ultimate disposal of that asset. Also, there are maintenance of existing easements and trails and utility lines that are required for those properties that may overall affect those values. And obviously, we also believe it would take longer than 180 days to sell those properties. Our estimate would be, well, the estimate that our subject matter expert told us was it'd take about 18 to 24 months possibly to sell those properties. So we have found though that Climax or CMC has demonstrated they have clear title of the property and that we have accepted their appraised value of the land. However, given the complexities we discussed, we do recommend that the board accept only 75% of their appraised value to count towards the financial warranty. For the Alkali Creek Ranch, it's a little different. The owner of the property is Mount Emmons Mining Company. Included with that title, we found that there is a right of first refusal or a ROFR, as we've been discussing it, for parcel A and B running to the benefit of the Span family. That ROFR would basically give them the right to buy the property should come for sale first. They would have the right to first refuse to purchase that property. And that would likely be triggered on any foreclosure or conveyance of the property, including forfeiture of the financial warranty. And that ROFR may have priority over other securitization of that property. However, the division and CMC have agreed to terms to be included in the deeds of trust, the actual promissory notes that we'd accept. That would ensure that the state would still get the funds with the sale of that property. So we've worked out the language basically to address this concern. Parcel A lacks direct access to a public road. I guess I would clarify it lacks assured access to a public road. There is an existing 2-track road that passes through U.S. Forest Service land to reach that parcel. However, a long-term right-of-way has not been obtained. Climax is working on getting a access agreement with the Forest Service to gain access to that property. However, that access that they get from the Forest Service wouldn't be transferable to any party in the future. Those individuals who purchase the property would have to go get access from the Forest Service themselves, which is from my understanding and review, that's not atypical. You know, there's lots of instances where that occurs. So ultimately, it'd be on the successor owner of the property to obtain access from the Forest Service. So in summary, for our findings for the Alkali Creek Ranch, we do accept their appraised value of the land. Mount Emmons Mining Company does have clear title to the property, and as a signatory of the promissory note and the deed of trust for the parcel, Mount Emmons Mining Company will be affirming their relationship with CMC and the consideration for placing its property in the financial warranty package. Due to the span ROFR and the access issue for the parcel A or the west parcel, we do believe a reduction in the value the board can accept for this property is appropriate. So the division recommends the board accept the Alkali Creek Ranch property as part of the financial warranty, but only at 75% of the value of the appraisal. Silver Springs Ranch, similar. The property is owned by Mount Emmons Mining Company. The parcel D also doesn't have access exactly. That parcel has to be accessed through parcel C, but those parcels are adjacent to each other, so it's less of an issue. We have found that the appraisal is acceptable, so that value is acceptable. Due to the access issue with parcel D and the possible impact on the sale of the property, because of that access, we do believe a reduction in the value of the board is acceptable and appropriate, and we recommend that the board accept 75% of the value of the property. So clearly, we recognize this has taken 3 years to get to this point, and so we did ask Climax to provide us some updated information in compliance with Rule 4.9.1 per 2B, which states that any person offering such financial warranty shall submit together with their annual report, as required by Rule 1.5, the following information: an update by a qualified independent appraiser indicating any change in the property value, a statement summarizing any circumstances which may affect the adequacy of the deed, if it is a deed of trust and security agreement, and proof that there is no past due property taxes. So we did find, based on a August 31st submittal that Climax provided, they did give us documentation from an appraiser and a water engineer that the values of the real property have actually increased since the 2020 proposal. And they have certified that there are no changes in any circumstances from the date of the original proposal, which may affect the adequacy of the deeds of trust. And also, there are no outstanding property taxes. Pursuant to Rule 4.1.2 per 8 and the statute there as well, the Border Office may refuse to accept any type of financial warranty if subpart A, the value of that financial warranty is offered, is dependent upon the success, profitability, and continued operation of the mine. And part C, if the board determines that the financial warranty offered cannot reasonably be converted to cash within 180 days of forfeiture. So for this rule, we have found that the value of the real and personal property offered as financial warranty is not dependent upon the success, profitability, or continued operation of the mine. We recognize that the assets may not be converted to cash within 180 days of forfeiture. However, the state would have to expend about $135,204,778 of the other types of financial warranty will hold, or about 79% of the other types of financial warranty, before we need access to those funds for reclamation. So that would give us time to allow for the sale of those properties. Any questions before I move into our recommendation?
Go ahead, Mr. Merrill.
Mr. Ebert, thanks for this. I think just one simple question. So as part of this on the properties, Climax couldn't put in any other just slipped my mind, the encumbrances on such as a conservation easement on the land or anything like that, did they?
That's a good question.
Yeah, and again, Jeff Higgett for the division. And I may defer some of that to the Climax folks to kind of discuss how they may use these in the future. I think any changes to the property would have to be identified in kind of their annual market updates, analysis, changes of circumstances out there. I think what we're most interested in is, does the state still have a priority in the event foreclosure of this property, the funds will still come to the state without too much fight with other creditors? And are they doing anything with property that impacts the value of that property? If the impact is significant enough, then that's something that the division would see if these are still properly held as a form of financial warranty or not. Again, the value of all these assets are high. There was never really a concern with the value of the property. It's always been based on the ability of the state to sell, convert these to cash in a worst case scenario where a foreclosure needs to occur. So I think that probably the most direct answer is I believe they probably could still encumber or do other things with these properties, so long as it doesn't significantly impact the value of the property or impact the state's rights under the terms of the deeds of trust.
As part of the agreement, then, is the operator required to notify us if there's a change in property value, encumbrances, sales? Denver Water picks up the Skylark water rights.
I believe, and I'll let Jared, I mean, rule 4.9 is kind of what is going to provide the annual updates to the division. So I think some of those changes, if there are any changes, would be captured or should be captured in those communications with division staff. And again, I think the close working relationship with Climax Henderson folks, if there is something like that occurs, they will be likely reaching out to the division to just kind of give them the notification that has happened or may happen.
Yeah, no, I think that's accurate. I don't think there's a rule that specifically states that they have to tell us that, but we are reviewing this every year. They're going to have to submit something every year that shows that nothing has changed in the conditions of which they posted this, and we are still the first lien priority. So if that changes within that year and it comes to our attention, which I'll get into next in our recommendation, that could potentially be not maintaining a financial warranty in good standing, in which case we could pursue enforcement actions if we needed to, like we wouldn't have to do that. But yeah, that is a good point. The client, they need to be aware of. They can't do something that would undermine this during, without our approval or updating it.
I'll wait and hear your recommendation.
And these properties are all virgin. There's no prior disturbances or liabilities with any of these.
Not mining related that I'm aware of. The adjacent Henderson Mill industrialized property, based on my review of the land appraisals and the pictures, they could probably answer it better. I don't think there's any. Well, I know there's no mining related disturbance, but I think there might be a cabinet or something like that. You guys might know better if there's a cabinet or something on there, but it's unassociated with mining operation.
That's correct.
Yeah. Same with the Alkali Creek and the Silver Springs Creek. I mean, they're obviously on the other side of the state. And there are some cabins and some upgrades to that, but they're not mining related.
And at the front end of this process, when we were looking into the nature of the appraisals and the review and what kind of information the division wanted to receive, we did have some discussions of having them perform some type of an environmental assessment. We opted against that. Just there didn't seem to be anything that indicated that was necessary.
Mhm.
And there was some significant cost and time delay in doing something like that.
Okay, thank you. And just on the rule, the proposal here on B, where it says submit an update by independent appraiser indicating any changes. So, I mean, it seems a little fuzzy to me. So they will have an annual appraisal every year of these properties?
Yeah, and actually our recommendation addresses that. What we've agreed to with Climax is that they would submit a market analysis every year to show that those properties have not dropped below the value that we've accepted. And every 5 years, we'll ask for a full blown appraisal.
Okay,
Yeah.
okay. Thank you.
Yes.
In your
Yeah.
recommendation.
Recommendation.
for
Okay.
questions.
All right, so we do recommend the board accept the interest in real and personal property as a form of financial warranty. Again, table 3 of your document there shows this table with the associated water rights and properties and the value of acceptance there on the far right, bringing the total warranty to $169,827,253. The current required surety is $171,125,253. So even with this proposal, they would have to submit an additional $1,298,000 $100,000 in another form of financial warranty in order for them to be considered fully bonded. So the terms of acceptance that we recommend is first being that CMC will be required to comply with Rule 4.9.1 per B on an annual basis. Therefore, they would be required to submit a market analysis for each deed of trust on that annual basis and require full updated appraisals every 5 years, with the first reappraisal due next year, October 1st, 2024. Part 2, pursuant to Rule 4.9.2 failure to provide the documents required by Rule 4.9.1 shall indicate a reason to believe the financial warranty is not being maintained in good standing as required by Rule 4.1.7, and the division shall pursue enforcement action in that case. Part 3, pursuant to Rule 4.9.2 a request for an increase in the bond by the office shall require reappraisal of the real property used as security for the bond. Part 4, in accordance with CRS 34.32.117.6 B and Rule 4.1.2.5, CMC shall annually cause to be filed with the board a verification by an independent auditor that of the close of their most recent fiscal year, CMC continues to meet all applicable requirements of the subparagraphs 4 and 7 of paragraphs F and subsection 3 or in subsection 8 of CRS 34.32.117. If CMC no longer meets these requirements, they shall instead cause to be filed an alternative form of financial warranty. And then the last 0.5 is that they would submit the net deficit of $1,298,000 of financial warranty within 60 days of today's board date. That concludes my presentation. Are there any questions?
Will you have some sort of encumbrance filed against the water end? So we don't have to worry about what they do after that, because they'll be junior or whatever our encumbrance is. And that's not a problem.
Yeah, the kind of the next steps after, should the board approve this financial warranty, we've been working with our consultants and Climax experts on finalizing the language for the deed of trust and the promissory note. Promissory note is essentially kind of the board's financial warranty form that has our traditional kind of boilerplate language about our rights under our act to foreclose upon property converted to cash for use as reclamation. The deed of trust has the other language in there that's kind of specific to the property. Some of the deeds of trust for the properties that are owned by Mount Emmons also kind of does a nice tying of the corporate entities together to kind of indicate how Mount Emmons is related in the corporate structure to Climax. So those will be recorded in the proper counties. We are very close to kind of final language on those. I think we're just doing a little bit of kind of nitpicking, and then we'll fill in the blanks with the appropriate dollar amounts and counties and get those filed. So yeah, they'll be kind of part of the process in those counties. Again, in the event the state has to move forward with any kind of revocation, there will be some priorities there.
Go ahead.
The recommendation to require an updated appraisal every 5 years, with the first appraisal due next year. Didn't we just go through the appraisals that explain sort of that?
Yeah, the original appraisals were dated from 2019 and 2020. So those they haven't been fully reappraised since that time. Okay. Yeah.
And some of that time gap, I mean, it is strange to kind of a less than a year after approval to kind of start again with full appraisals, but we recognize there is some staleness to the appraisals that are part of this package, but we didn't want to restart the clock for the process just to get updated appraisals. So we did just kind of the market analysis is just a quick check-in that everything is still in good standing. In fact, they've indicated they've increased in values, and so we'll kind of restart next year and get this on a tighter schedule. As Jared indicated, the water rights that the division currently holds, I think they were approved in 2006 time period.
Yeah, 2005. 2002, 2005.
There were some gaps in the administrative record. And so when we were working with the company to release some of those water rights in 2020, it was hard to piece all that together. And so part of this effort is also to construct a better administrative record, better record keeping generally, and updates to the board so that 10, 15, 20 years from now, when people are taking over our roles, they have a sense of what happened and why it happened. Or in the event that some of these properties are released, there's an easier process to kind of facilitate release of those water rights.
One point of clarification, they did submit an updated appraisal of the Alkaline Creek Ranch property in 2022. We had a lot of back and forth specific with that parcel or with that property. So that one is a little more fresh, but I don't want to have two different tracks going for different properties. I'd like it all to be one time frame.
And then it's probably on the record from our discussion in, what was it, 2020? Can you remind the board, is it strictly the operator being able to provide real interests such as these in which we engage in these conversations, or is there some other considerations that we have before pursuing the path of swapping out property for a surety bond?
Really, the rules allow and the statute allow for this type of bond. So it's really up to the operator which form of bond they want to supply. And this is the most, like, it's financially advantageous for them because obviously there's costs associated with, you know, holding a corporate surety or posting that, they're giving some relief with this type of bond. So it's more incumbent upon the operator to work with us to get this in place. It's very rare. I think this is the only company that I know of in Colorado that has this type of bond in place. Because obviously there's a lot of hoops that one has to jump through in order to get to this point, for sure. So it's not an option that most people elect. And, you know, we had obviously some trepidation back in 2020 with this. We're not realtors and stuff like that. So we didn't feel like we had the expertise to really review these properly, but that was why we went through this whole process to get the due diligence done.
And an important aspect too and stuff is this option, as noted, is CMC is the only one that has taken that into account. We only had one company that was big enough to do self-bonding, and that was eliminated with 1113, and that was Exxon. So the bigger companies and stuff in that with these mega bonds, if you will, and that we do want to take a look and stuff to see if there's some way and stuff in that to put together something that helps out certainly the operators. It's a huge lift. And so we have had other operators come in and inquire about it. And we've explained to them what is entailed in that. And also those other entities and stuff have wanted to use it for 100% of the bond. And we point out that that like this one's only 21% of it, and that the rest of it's in normal corporate sureties and that. So it certainly is unique in that, and we would like to keep it that way.
I think not to maybe pile on and get duplicative. I think the Russ's point of this is not 100% of this form of bond was some of what was appealing to the division to pursue this. Not only working with Climax, who's got a good reputation in the state and have been great to work with in the past, but as the presentation indicated, these are going to take months, potentially 2 years to sell. The fact that it is only 21% of the total bond means that, again, in worst case scenario where there needs to be a conversion to cash for the state to conduct reclamation and water treatment up there, they've got that cushion where they can have 2 years spending the corporate surety funds that have been foreclosed until these properties sell. That option's not available if these forms of bonds are 75% or greater of the total bond. That puts the state in a tough spot of having to potentially rush to sell property at reduced values and may not have sufficient funds for reclamation costs. So I think there was kind of a combination of a variety of factors that made this make sense for this particular circumstance. It's not going to work for other operators moving forward.
Sounds like we came to a point where there's a mutually beneficial path forward, given the unique circumstances. Protect the state's interest, taxpayer interest, right? And also working with a company that has shown a track record of wanting to do the right thing from the beginning, and being forthcoming with it. So thanks for that chronicling of all the work that went into this, and thank you for that work, both sides, the state and Climax. Is there any more questions? Or comments?
Operator has.
The operator, yeah, if you want to provide some additional information at this point.
Thank you all.
Oh, okay. Okay. Actually, before we get started, we might just do a quick bio break, just bathroom.
Okay, yeah, that'll give us time to figure out how.
Perfect, yeah, we'll come back at, we'll just say 10:30. Does that work? Sure. Yeah. Cool.
I think I figured out.
Okay, yeah, well, I'm glad,
Mouse
I'm
sequence.
glad you're doing. it. So I was like, oh, I have to pay attention to your parents' stories, so I know I'm supposed to.
Yeah, I may have just changed.
But, yeah. whatever.
So
Miguel Hummer, the environmental manager for the Henderson operations.
Great, thank you.
I'm also here with Jim Sanderson and Sheila Stack. And they're also supporting Climax on this matter, and just if there are any questions that they might need to answer from the board. So first of all, I'd just like to thank the division staff and their counsel from the AG's office have been working with us, as Jared mentioned, for the last several years. There's been a lot of back and forth documents, reviews, and everything else. So really appreciate that they've kind of stuck with us through this time and kind of got to where here at this hearing today. I do have a presentation. Jared really has covered all of the same materials I have in much more detail. So I don't know that I need to go through it. Really, I'll just have it available. If there are questions that I can use from the board that maybe it would support the answers or to bring up along the way, I can bring up the slides at that point in time. And we don't need to, unless you'd like to, we don't need to belabor or kind of extend this portion of the hearing. That works. So I just will mention that this is, I mean, it is a very important matter for the Henderson operations and for the company. I think as was discussed, mentioned by Jared, there is a significant financial kind of burden to be able to hold surety bonds. And so even this portion of a small percentage of the total financial warranty really helps out our overall kind of finances through the ups and downs of the molly markets and everything else that may be in front of us. And we do have a long, another at least 15 years of mine life, and then through closure, probably another 10 or more years to close. So that's an annual rates that we would pay, and then that would extend over all the life of the mine. So certainly important in that respect. I think we've kind of addressed and fulfilled all the requirements of the regulations and statutes to be able to implement this, and appreciate the divisions kind of working with us on that, and then their recommendation for approval of the 75% essentially of the value of those holdings. So with that, I'll open it up if there are any questions for me or for the company. And that's all I have.
Thank you. Mr. Monk.
Mark, good to see you again. Thanks.
Yeah.
For being here. It looks like we're a little bit off from the CMC proposed acceptance value by, I think it was a couple of million. Is Climax molybdenum good with that?
Yes, certainly. We're already holding, I think 132 million right now in surety bonds. And so we would be able to just add that additional, I think 1.3 million essentially to those other bonds. And we have the implementation, the financial institutions kind of that working the relationship with them to add that increase within the 60 days as the division had recommended and required.
Yep. And just wanted to say thank you for the organization working with the RMS and staff and Mr. Ebert. And I know it's been a process. Appreciate your patience in the partnership.
Yeah, thank you.
Just a kind of couple items. I'm very impressed with your what you've done to your properties, at least on Fremont Pass, in terms of reclamation, and that's a good thing and a good testament to you. But have you, and but not just trying to stir up any more confusion or thoughts, have you investigated conservation easement opportunities on that? I noticed they were praised for small ranches, and we don't need any more of those in Colorado, particularly in my opinion. I mean, and I don't know whether it would be your benefit or not, but if there was an avenue to do that, I'm sure encourage you to look at it.
Okay. Yeah, I'll kind of bring that back. I don't know that we have a pretty large organization, corporate group that works on land holdings and how they what makes sense from an overall long-term perspective. And so I'll certainly bring that thought back to them and see what opportunities we might have. We do we do have certain access agreements, I think, as Jared kind of alluded to with the Forest Service for trails through certain properties to access recreation and Forest Service lands through and the like. So we've been certainly open to doing that type of access in the past, where it can mutually benefit different parties and support the community or other interests, public interests there.
Well, I thank you both for working, and I thank the staff for looking for new dimensions for, protecting Colorado, and, our history started largely with mining in Colorado, mining. Trapping, so it's important for us to keep that viable if we can, but we've got to at the same time protect, what Colorado is all about, which I think your company's been really good. I appreciate that.
Thank you.
I know when we start, I live downstream. I got downstream quite a bit on the Arkansas River. And, when I was a kid, California Gulch, that was a problem. Now we got 106 miles of gold medal stream on the Arkansas. It just shows what we can do as a population.
Yeah, no, it's a good example. I think we can kind of have both the mining history in the current day as well as the other recreation and preservation and reclamation. So appreciate that. Thank you.
All right, well, anything else from the board? Comments? Yeah.
Mr. Chair, I would just want to take a quick moment just to kind of pop in and really thank CMC, IMAX and their team and stuff, especially Miguel and Sheila and Jim for all their hard work on this. And there's others and stuff that were in the background and stuff that were helping on that, as well as our consultants and stuff. The way this was set up, it just so the board knows is that but we picked the consultants and Climax I had to foot the bill for that, and that's within the act and the rules and stuff for that. So it's a clunky system, but we got through it and stuff. But certainly Amy, Bonnie, and Brett did a great job there. And also hats off and stuff to Jared and Jeff and that who kept this thing going and did all of the big heavy lifting on it. But I just wanted to take the time and stuff to thank everybody on this, because it was a 3-year project and that, but we got it across the line. I think, I guess you guys got to vote yet, but it was a big effort. Thanks to all those guys for doing that.
Cool, thanks Russ. All right, well, if there's no further discussion, I could take a motion. Yeah. Oh, sorry. Yeah. Any further deliberation? Sorry, my apologies.
Not a problem. What kind of emotion exactly do they need?
I think just really the staff's recommendations on the terms set forth. Do we have to stipulate the 75% value in the motion?
I think you could,
Value of the
or
appraisal?
just adopting the proposal and agreement.
Okay.
Because it's all. That's it.
Okay, gotcha. All right, well, I'll move to accept staff's recommendation for the financial warranty in the matter of Henderson Mine, permit number M-1977-342, to accept interest in real and personal property for that financial warranty in accordance with CRS 34-32-117, parent 3, parent B.
Second.
All right. John got a second. All right. All those, any further discussion? All right. All those in favor say aye.
Aye.
Those opposed, hearing none. Motion passes. Thank you all for for coming here today.
Thank you.
Well, Chuck wanted me to provide controversy. All right, well, believe that was our agenda for today.
Just quick
A
update.
quick update for the
Discussion.
board at this point in the discussion. Yeah.
Russ Means for the division, and that I just, for the discussion item for this month, don't have a formal presentation or anything like that for you guys. But just wanted to give you a little bit of an update on some of the things that staff's been working on. We started a public notice transparency project. I brought that to your attention. Last month, we met with the Soil Conservation Commission actually in early September down in Mancos. And I went down there and did a presentation to the Soil Conservation Commission. And then we followed that up with a coffee hour towards the end of the month where we actually were on a Zoom meeting with some of the staff as opposed to the commission to talk about our processes and stuff for public notice and some of the things and stuff that we do to send to them and the things we're trying to do and stuff to improve that process so that they're getting notices more timely. And that so they have more time and stuff to make comments and stuff that come back to us and that. So on that same note, we are scheduled to meet with the Division of Water Resources in early November. And that and kind of go through the same process there. And we are hopeful that we're going to be able to set something up with Colorado Parks and Wildlife in January or February when they're not quite so busy and stuff with hunting and fishing and stuff so that we can go through those processes and stuff so we get meaningful comments back timely and that and also identify any areas and stuff where we can improve our processes and stuff with them. Last week I had a chance to go to the Western Slope. I met with the Western Small Miners Association down in Natarita and there's a little bit of buzz. The price of uranium's coming up. So we were talking a little bit about some of the permitting issues we have. We have several mines and stuff that are under reclamation only board orders. They're trying to get through some of that. But we also have some mines and stuff that are poised and stuff that if the price of uranium comes up, they can mine. But the bigger issue and stuff is where to send it. And that goes along with, we did a tour actually of the White Mesa Uranium Mill in Utah and Blanding last week as well. The big focus there and stuff right now is kind of a big rah-rah, if you will, about rare earths. They're that mill and stuff is looking at, they have processes and stuff and they're building more in order to do rare earths milling and stuff here. And it would be the only mill in the United States right now that would be set up for that. So that's kind of exciting because the rare earths and stuff are also tied in a lot with uranium and vanadium deposits and stuff that we have. So, and then finally, we put out a groundwater guidelines and stuff on our website. That's primarily to help construction materials and new applicants and stuff in Hard Rock and DMO. It's a thank you to Patrick Lindbergh and the groundwater task team and stuff in that for a lot of work on that. So that's out there. It's kind of it's just a framework so that when somebody comes in with a new application or an amendment, they at least know what they're looking at and it opens the door for further discussions with the division prior to somebody spending a lot of money on setting something up that may not meet the needs for permitting. So, but that's out of the website and stuff now. So that's what I have for you this month. And with that, Mr. Chairman, I'll turn it back over to you unless there's any questions.
Yeah, no, exciting updates. Thanks for us. Any questions, comments for us? All right. With that, I'll adjourn the meeting. Is there any public comment, first of all?
No.
All right.
I know all of the.
All right. Great. All right.
And no executive session.
Thank you all for your attendance today and have a good rest of your day.
Oh, okay, all right. We have lunch coming.